My name is Nicole Howell, and I'm the Executive Director for Ombudsman Services of Contra Costa, Solano, and Alameda. And I'm pleased to be here with you today to really dive into an important and meaty topic of is it civil, is it criminal, or is it self-determination? So for those of you who are new to our sessions, I want to welcome you to our learning process here. And for those of you who are back with us, I want to welcome you back. As a reminder, this is an integrated process and we're all working together. So I want to remind you and encourage you to type your questions into the Q&A box. And I want to encourage you by getting started right now in the chat to drop your name and where you from, where you work, what you do, so we can all get to know each other. So take to your chat box right now and introduce yourself. Also, we are pleased to provide, thanks to California Department of Social Services, closed captioning, as well as ASL interpretation. If you are using the closed captioning, please select subtitles settings. As a reminder, we're here every third Thursday of the month from 12 to 1. With the exception of December, we've moved to accommodate the holidays. And at the end of the session today, we will drop in the chat the registration for next month. As a reminder, this is provided to you from our organization, but this program did originate in Solano County, the Elder Justice Forum, with one of our speakers today, Krishna Abrams. We also have a sponsor through Kaiser Permanente and distinguished planning partners of California Department of Social Services, California Long-Term Care Ombudsman Association, the Commission on Aging, the Office of the Long-Term Care Ombudsman, Department of Aging, and Public Authority, Public Guardians, and Public Conservatorships. So today we have drawn together a group of people who I consider friends and colleagues and really experts in the field of elder justice. So I'm going to toss it to them momentarily, but I want to do a little level setting first. And so I think for all of us who work in the field of elder justice and elder abuse, we really wouldn't be true to ourselves if we had not acknowledged that at some point we have maybe said a bad word frustrated about not being able to get a client into a certain program, or not being able to convince another program that they really do qualify or are beginning to lack capacity. And I think so much of us are often caught in that space of frustration. And I think much of that comes from a misunderstanding of what different programs and government organizations are able to do and how that differs by community. So our goal today is to learn from each other and hear how each of these individuals sees specific scenarios as it relates to elder abuse, as well as to look at some systems issues, to start thinking about what you can adopt in your community and what we need to raise up as a team to larger organizations, to government officials about how we can address elder abuse in our communities, particularly from a preventative model. So I want to remind everyone to, again, write those questions in the Q&A. I'm going to turn it over to our speakers, and we will come back at the end and you will get a chance to ask some questions of them. So with this, I'm going to turn it over to Jill Nielsen. She's with the City and County of San Francisco. Jill?
Thanks, Nicole, and thanks so much to all of you for joining us today. It's my privilege to be part of this panel discussion, and I thought I'd get us started by sharing the story of Vicki. Vicki's a resilient older woman who I had the privilege of meeting about a decade ago. She lived in Hayward in her own home when I met her. And her grandson had lived with her for several years. And unfortunately, as he became a young adult, he became involved with a street gang that was engaged in criminal activity. Over time, Vicki's home became the epicenter for the gang's drug sales. With members of the street gang in her home all day and night, she was afraid to even leave her bedroom. An extended family member tried to help her, ended up assisting her to have a metal security door installed outside her bedroom just to help her feel safer. But she was really intimidated by the individuals who had taken over her home, and for many months she evaded efforts to help her. It was only through the collaborative interventions of the Hayward Police Department and social workers from Adult Protective Services that the gang members were arrested. Criminal restraining orders were obtained. APS connected her to nonprofit legal services providers and ongoing social services that were focused on keeping her safe and independent. Her story is from 2010. but it's still relevant today. And if you want to hear more about her story, it's actually part of a short documentary called An Age for Justice, and it's available on YouTube. And that video was actually made at the time as part of an advocacy effort to support the passage of the Elder Justice Act. So Vicky's story really demonstrates that elder abuse cases by their very nature are complex. Next slide, please. They often involve multiple forms of abuse and self-neglect. Individuals who experience abuse often have diminished capacity, and that makes it hard for attorneys or law enforcement or even social workers to assist them. Family systems or the older adult themselves may be grappling with substance use issues or serious mental illness. And especially with the financial abuse cases that we see, exploitation can range from scams, professional perpetrators, to adult children who are just helping themselves to their inheritance early and may not even know that they're committing a crime. Next slide, please. Resolving elder abuse cases is not always a straightforward process. In order to properly intervene, we have to account not only for the older adult's safety, but we also have to balance their own wishes and goals and their right to self-determination. And additionally, we have to plan for their long-term care needs. And usually the cases that we see, that's happening within an environment of very scarce resources. And of course, there's always conflicting views from family members, and that can make it much harder to identify what the best course of action for the client really is. Next slide, please. So there are multiple intervention pathways to consider. And in general, when we're looking at those pathways for elder abuse, we can break them down into three categories: criminal justice, civil remedies, and social services. And these pathways are not mutually exclusive, and that's what we saw with Vicky's case. Often the elder abuse case requires assistance from all three sectors in order to really reach an appropriate resolution. Next slide, please. So I'll just speak briefly to social services interventions. A primary safety net program that we have in California as well as across the country is Adult Protective Services. I won't delve into detail about the role of APS. Last month's webinar actually featured Lori Delagrammaticus, the Executive Director of the National Association for Adult Protective Services, and she spoke already about APS. But what is critical to know about the program is that social workers are required to respond on an unannounced basis to reports of abuse, neglect, exploitation, and self-neglect. For adults with disabilities, as well as older adults over the age of 65, and specifically for those who live in the community and in non-licensed settings. And although there's a lot of talented APS social workers in California, I have many on my team in San Francisco, I have to admit that I've heard on many occasions an accusation that the program didn't do anything after they went out and responded to a case. And if that's been your experience, more likely than not, it's due to the fact that the program has to follow this guiding principle of self-determination. The right of adults to folly is maintained, and there's really only a few exceptions to that rule. And I'll talk about those in just a minute. APS is very effective, though, at initiating responses from other sectors as serving as a catalyst. In California, APS programs are required to report suspected and confirmed abuse to law enforcement. And APS programs usually have a really close relationship with their local nonprofit legal services provider, and they'll make referrals to those providers for a variety of services. And of course, APS workers are really adept at connecting clients to social services that are really focused on remediating abuse. So what about conservatorship? Next slide, please. Conservatorship, or guardianship, as it's known in many places outside of California, is only an option in a small minority of cases. It's only considered an option when we know that there's a significant protective issue that threatens the individual's health and safety, and that the individual lacks capacity. Next slide, please. In California, broadly speaking, there's two types of conservatorships. LPS conservatorships are reserved for adults with serious mental illness who are considered to be gravely disabled, or they're unable to provide for their own food, clothing, and shelter, which is the definition of grave disability, and I'm sure many of you know that. LPS conservatorships are grounded in recovery principles, and so they tend to be shorter term than probate conservatorships, and they have to be renewed annually. For most elder abuse situations, we're thinking about probate conservatorships. Those are designed to protect individuals with cognitive impairment, usually deteriorating dementias such as Alzheimer's disease. And usually probate conservatorships will be in place throughout the duration of the individual's life once they're initiated. Next slide, please. So both types of conservatorships have a few key concepts in common. They can only be pursued as a last resort, and all other interventions have to be attempted first, and you have to be able to demonstrate that to the court. And conservatorships have to follow the principle of least restrictive intervention. It must be the least restrictive intervention available, and along those lines, the setting where the individual will reside has to be the least restrictive setting necessary to meet their needs. The court will always defer to families, especially if the family members are able to show that they're reliable, they're willing to act. And really critically important is that the conservator petitions the court, has to present to the court a reliable ongoing care plan for that individual. Next slide, please. So when the public guardian petitions for conservatorships, they typically will request authorities to act as conservator of the person as well as the state, and that allows them to make both medical and financial decisions on behalf of the conservatee. But it is possible to petition the court for only one authority area. And the responsibility, though, the legal duty for the public guardian to provide for the ongoing care need, it can stand as a barrier for your local office to take a case, because that's also something that I've heard many times. Why doesn't the public guardian take my case? And this is especially true in cases where for clients who are low income and there's no way to pay for their own care out of their monthly income or through available public benefits. And in California, I think it's important to know that we don't have dedicated funding for counties to operate their public guardian programs, and there's no state oversight of the programs either. So as a result, you're going to see some variation between the practices and the protocols of the local public guardian. But ultimately, these offices are accountable to the courts and to the court investigator's office. So from here, I'm going to pass it to Krishna. We're going to be looking at criminal interventions to elder abuse.
Thank you, Jill. First of all, Nicole, I want to thank you so much for putting on this forum. This is a very important issue, near and dear to my heart. And, you know, obviously these are some of the most vulnerable victims that we deal with in the criminal justice system. So thank you for putting on this very important forum today. I just want to talk about, like Jill said, that, you know, elder abuse cases are very complex and they're very challenging to prove criminally. You know, we have an ethical obligation as prosecutors to only file those charges that we can prove beyond a reasonable doubt. And so oftentimes we face a lot of challenges in trying to actually prove a criminal offense in these kind of cases. But our office gets involved. We get phone calls, we get emails, we get walk-ins, we get referrals regarding possible abuse of loved ones. And so we look into it. And we know, you know, our office looks into it to determine whether there's any criminal culpability. And elder abuse, as we know, can come in many forms. We talk about physical abuse and elder abuse. Typical situation that we will have, you know, say a son assaults his mother pretty significantly. You know, we had a recent case where, you know, he broke his mother's ribs. The mother is very scared. She calls the police for help. So we get involved. She sustained a serious injury. We know she has identification of the perpetrator, which is her son. We know that the son knows she's 65 years or older, so therefore she qualifies as an elderly victim. And so we review it and we see that, you know, charges should be filed. We believe that we can prove it beyond a reasonable doubt. So we get a criminal protective order in court and go to court. And then some of the challenges we face in those type of cases is that, you know, the son lives with the mom no longer wants prosecution. She says she's not scared of him anymore. She doesn't want her son to have a felony. She doesn't want him to lose his job. She says he won't do this when he's on his meds. He was only off of his meds. So in a felony case, we go to a preliminary hearing. In a preliminary hearing, she may testify and really minimize what happened to her because she doesn't want these consequences for her son. And then she's asking for us for a dismissal. So we're kind of caught between, you know, we want to make sure that this victim is kept safe. We want to make sure that the offenders are held accountable. And we want to make sure that the offender doesn't do this again. So that's kind of some of the challenges we have in the physical abuse cases and elder abuse. We also have a lot of cases in financial abuse of elders, and that, depriving an elder of their money or their property by theft or forgery or fraud or false pretenses. A lot of the cases involve real estate fraud that we look into in terms of for forgery or for fraud. And then we also look at cases where there may be endangerment of an elderly, kind of like child endangerment, but the endangerment of an elderly person. And that's placing them in a situation that endangers their health or their safety, neglect, abandonment, isolation, causing mental suffering, or depriving them of the care that they need. So, as we talk about elder abuse, it comes into our office, funnels into our office from a number of sources, and determine, is it financial, is it physical, is it emotional, is it sexual? There's all kinds of elder abuse. As long as we all know, an elderly person is described as a person that's 65 years or older, and that the perpetrator who may have committed a criminal offense against the elderly person knows or reasonably should know that the person was 65 years or older. So when all these kind of cases come into our office, whether it's a call from a loved one or it's a report from APS or a report from the police department, we have a specialized investigator, Elaine Perry, who just specializes in just elder abuse crimes, and she'll do follow-up investigation to determine whether there is any criminal culpability on the part of the lead or the suspect in the case. And then once Elaine makes sure that she does all the follow-up that's necessary in these type of investigations, again, a lot of times, a lot of the conduct is really bad, but the question is whether we can prove it criminally beyond a reasonable doubt. So then our investigator will then get with an attorney from our family protection unit and determine whether we can prove that case beyond a reasonable doubt. And then if so, we would file the case in court, and we would proceed to court with the victim advocate obviously for the elderly victim, for court advocacy, and also for any victim compensation that the victim may be entitled to. So then we go through court, we make sure that there's a criminal protective order during the nature of those proceedings to make sure that the victim is protected throughout the criminal case. So our goals, in the prosecution is, number one, that we have to be able to prove the case criminally beyond a reasonable doubt. And that we always hear from the victim, that the voice of the victim is always heard, that the number one priority is that the safety of the victim. We want to make the victim whole, obviously, especially in these financial abuse cases. And we want to make sure that the offender is held accountable, responsible for the crimes that may have been committed so that they do not reoffend. So that's kind of just in a nutshell of what we do from a criminal perspective.
Thank you so much, Krishna. I appreciate that. And I want to say that what Krishna's done is really amazing is she actually has an elder abuse investigator in her office. And that has been a really great help for us as community partners to be able to work with them and understand and refer back out to others when they might not pick up a case, but the person needs services. So I think that's a real credit to Solano County, and we appreciate that. Thank you. I want to remind everyone we will be providing the slides and the recording early next week. So be sure to know that you will get that, and we appreciate that. And I think now it's going to Jim.
Thank you, Nicole. First, I just wanted to say thank you for gathering us. I think this is a really important topic, and understanding the intersections of kind of how our work overlaps and how it can really create positive outcomes for older adults is a really important topic. Just for some level setting, my perspective is going to be from the County of Alameda. And so some things that, we do are, like Jill and Krishna mentioned, might be done a little bit differently in different counties. And so our role in this is really on the civil interventions to elder abuse. And as mentioned in Jill's slide, legal assistance for seniors in Alameda County would be that legal services provider. So to give you some background on us, we are a 501c3, and so we operate like a normal nonprofit in that we do provide services free of charge to older adults on a wide variety of topics, including elder abuse. And I would mention that in Alameda County, we have one of the most powerful things we're going to be talking about is collaboration. And I think that is the ticket to really solving and helping clients through these cases is a really holistic perspective. And in our county, that means having groups that we meet with regularly with our DA, with Adult Protective Services, with a variety of community-based organizations and government organizations to make sure that we have a very broad perspective in terms of the solutions that we're looking at to solve these complex cases. Because the reality that I like to tell my team after 11 years is I've yet to meet the client that comes into Legal Assistance for Seniors doors that just needs legal services to thrive. And so we really need to open up our perspectives in terms of what we can provide to make sure that the older adult is whole, and we restore that dignity and that independence to the older adult. And so in terms of civil interventions to elder abuse, there are really two categories I'm going to talk about. One is protective legal measures, and the other is restorative legal measures. So I think a little bit different from both Jill and Krishna is that we have a very standard kind of boilerplate attorney-client relationship with our clients, which means that everything we do is driven by the client and the client's wishes. And so that gives us a lot of ability to really tailor our interventions to what the older adult wants, wishes, and wants to pursue. The most basic protective measure that we encounter is elder abuse restraining orders. And I think where civil restraining orders tend to have a little bit more flexibility than the criminal restraining orders, and that is really beneficial for a lot of clients. I think the example that Krishna just brought up is a really good example and is pretty typical, where the abuser that we're looking to restrain is someone that is actually fairly close to the older adult. And so an order where they can no longer speak with, see, be in communication with that person for potentially years on end is overwhelming. And the reality is that might be somebody who they still want to have a relationship with. And so part of the benefit of the civil side is the elder abuse restraining orders are very clay-like in that they're moldable to the wishes of the client. And so we put in all sorts of provisions that, you know, if the grandsons say were sober and, you know, they could have phone calls 2 times a week, you know, they might be able to meet in person in public at a Starbucks when that is allowed again. To have some type of contact. And I think really the hope in creating those interventions that are a little bit more tailored are that they will actually be useful to the client. And so, you know, a lot of times if the order is too restrictive, pretty quickly what we'll see on the civil side is the client will call back and say, you know, I've really been thinking about it and I actually want to see my grandson. And so we're trying to kind of really balance making sure that we're protecting the older adult and making sure that it meets their needs for their family. Some other protective measures in terms of financial abuse might be executing powers of attorney, advanced healthcare directives, and really what these are some kind of basic planning documents that could remove an abuser from the decision-making process for that older adult. You know, they're easily executable documents, meaning that someone could put a power of attorney in place. An older adult can get a power of attorney fairly easily. And unfortunately, agents under those powers of attorney have quite a bit of power to act on their behalf. The upside is those powers of attorney are easily revocable, meaning that, you know, when if abuse is discovered, those documents can be revoked fairly quickly. And the last protective measure that I would talk about broadly is conservatorship, which is easily the most complicated, and I say we will probably not fully get into. I think we could do 90 minutes just on conservatorship. This differs from county to county, but for legal assistance for seniors, our role in that process is we're actually court appointed to represent the proposed conservatee. So in that role, what that would mean is that I am purely advocating for the wants, wishes, and rights of the older adult in that process. So even if a conservatorship may be appropriate, there are certainly, we push back on all sorts of issues, certainly the sale of a home, having to move a client, conditions of living. So there are all sorts of ways that a conservatorship can still be in place, but the older adult's wishes can still be honored, and that we want to provide as much independence to that older adult continuing forward as possible. The next category of kind of civil interventions, which legal assistance for seniors and a lot of, at least the nonprofits I know of that are in this space, are a little less involved, is restorative legal measures. And that really can include civil suits for financial abuse, the undoing of executed legal documents, including wills and trusts, you know, annulment of marriages. And this is really where thinking of elder abuse in much, much broader terms is really beneficial. I was talking with the fellow panelists earlier about one case where I was thinking about it for this presentation, where we had family law attorneys, we had a civil financial elder abuse attorney, there had to be family law attorney, there were criminal charges, legal assistance for seniors was involved with restraining orders. So I mean that, you know, there were 4, 5, 6 agencies involved taking different slices of the intervention in their expertise and making sure that that older adult is made whole. So I bring that up to say that, you know, when I talk about these collaboratives, when we get to sit down with the DA, when we get to sit down with the Ombudsman and with Adult Protective Services, really what we're doing is making sure that we're casting the net broad enough that we're covering all of the needs of that older adult. And I can't overstate how crucial that is in being able to really fully serve older adults. Next slide. So I think what we're gonna do next is we're gonna run through a case scenario, and then what I'll do is I'll read the case scenario, and then I'm gonna turn it to Jill and Krishna for their thoughts, and then I can kind of weigh in too. So it's really basic, but that's kind of in vague, but I think that's intentional. And so, you know, we can kind of run through what questions we would ask, how we would follow up. And so our case scenario follows Terrence, who is a recent widower living in his own home. He had estate planning documents completed by Terrence and his deceased husband bequeathed their home and assets to animal shelters. Terrence has 2 children, Jessica and Bill, from a prior marriage. 6 months after Terrence lost his spouse, he suffered a stroke. As a result of the stroke, Terrence has memory loss and his son Bill moves into his home to care for him. Bill takes Terrence to have a capacity declaration completed and then has his father sign over the deed to his house and creates a new will. In response, Jessica has Terrence appoint her as his power of attorney for finances, and she removes $50,000 from his bank account for safekeeping. So I would turn it over to my panelists of kind of what red flags does this raise for you? Where would you start? Kind of what are some of your initial thoughts on this particular case?
Sure, I can just chime in that this would be this is a very typical case that Adult Protective Services would have to investigate. Adult Protective Services programs, likely across the country, certainly in California, are regularly called in to investigate what might be considered family disputes. But of course, in this case, what we really see is that both of these children have broken the law. They may be doing so thinking that they are just protecting their father. They may not be aware of the protections that are in place to protect older adults, and especially vulnerable older adults like Terrence, who suffered a stroke. So APS in this situation would come in on an unannounced visit and would interview Terrence alone, try to find out what his perspective on the situation is. And then from there, have to interview both of the children, find out what their perspectives are, why they have completed new advanced legal planning for him, and why they're not communicating with each other. It's going to be tough to sort out. What I can tell you is that Adult Protective Services will need to make a police report. In an ideal world, Adult Protective Services would then investigate in tandem with local law enforcement. That doesn't usually happen. What we see is that local law enforcement, especially a case like this, which involve complex allegations of financial exploitation involving real property, involving thefts from bank accounts and really complex issues, will have to be turned over to local law enforcement and a qualified specialized detective. And so my experience is that those detectives have backlogs. And so very often Adult Protective Services is intervening on a social services side while law enforcement takes an initial report and the case gets in line for investigation. The Adult Protective Services social worker will try to find out which of these children, if either of them, could be considered reliable. Do either of them have their father's best interests at heart? And so if neither one of them are reliable, then the case could be considered for probate conservatorship. Seems like there are 2 different capacity declarations that have been completed. APS programs, as a matter of practice, certainly in San Francisco, we do obtain capacity declarations to try to determine whether our clients have the ability to make their own decisions or not. And if the client lacks capacity, and if there aren't any other methods for protecting Terrence, then this would be a case where we would consult with the public guardian. The public guardian, in turn, would have a very, they would have to demonstrate to the court that neither of the children would be reliable caregivers. That could be tough if they come in and contest the conservatorship. So that would be one of the most significant barriers that the public guardian would have to face in trying to determine whether whether they should move forward with a petition or not. Having local law enforcement investigate, and if local law enforcement is able to determine whether criminal elder abuse statutes have been violated, would be very helpful. And that would be helpful for Adult Protective Services and for the public guardian to determine what the next steps are. So now, Krishna, maybe you'd like to chime in on the criminal role in a case like this.
Sure. So I just want to say, when Jill referenced that, the police department would have to then make a report, after APS got involved. I will just say that the police departments, their resources are pretty strapped. And so usually these type of cases do end up at the DA's office for a DA investigator to get thoroughly involved in the investigation of the case. And so, and like Jill said, these are complex. They take a long time because there is a lot of documents involved. And so when I read over the scenario and just heard it, there's a lot of issues that do come out. And so when, it looks on its face like, okay, both Bill and Jessica broke the law. But again, like I said in the beginning, it's like, we have, an ethical obligation to only file those charges that we can prove beyond a reasonable doubt. So these type of cases, you have to really get involved. So it can't just be what you see on its face. So for instance, Jessica's reported, at the end of the scenario that I have, Jessica's reported that Bill is basically abusing their father. And so you have to look at, well, what happened? Did he really transfer the deed over? Did he to the house? Did he give him, everything to Bill? Why did he do that? Like when Jill talked about, self-determination, did he have the capacity to do that? So we look at the criminal component on behalf of what she's alleging about Bill, which would be, did Bill get the deed to the house through forgery or fraud? Was that executed? Was it notarized? Was it recorded? These are all things that we follow up on. For instance, our DA's office has the recorder's office send out a notice to any transferor of property at the time a deed is recorded. So it alerts the owner of the property that, hey, there's been a deed recorded on your house. And so we feel like that's helpful to residents in our community. So the question would be, if it was notarized, we would want to look at, like Jill said, that there'd be an APS report. We would initially look at the APS reports, the police reports, if any. We would want to know all statements. We'd want to review all statements. Obviously, Bill would need to be interviewed. Jessica would need to be interviewed. Terrence would need to be interviewed. And he's what's really, really important. However, in looking at the scenario, it sounds like there may be some reliability issues in terms of his statement and his memory and what's happening. And so, there's things in the scenario that you go, well, wait a second. He wanted to be closer to his son. He's bummed when his son moves out and Jessica takes over. So maybe he did want to, have a last minute decision to, give the property to Bill because Bill's been sitting there at his house taking care of him. So there's some issues, but we'd want to look at any and all witnesses that of any of the transactions that took place between Bill and his father. And really the question would become is, did Terrence just want to transfer this property to Bill after, his husband died, or was Bill obtaining this property through forgery or fraud? That would be criminal in nature. But at the time that we would be looking at all of that, there's issues about Bill, but then in the scenario that we were given, our investigator would obviously want to also look at Jessica's involvement, because now we have Jessica going and becoming power of an attorney, going to the bank and withdrawing $50,000 from his account and putting it in her own, which may obviously violate one of her fiduciary duties as the power of attorney in removing his money and placing it in an account of herself. And, the questions would arise of who else was on Terrence's account. If it was just Terrence, why did she feel the need to move the money? when Bill wouldn't have had access to it. So we would want to look at, you know, the documents that she provided to have power of attorney, what if anything was filed, what if anything, like I think you guys talked about, was valid, what was her intent. And again, when we get, these are very complex, like Jill says, and when we like kind of go through all the documents and all the interviews and all the statements, you know, you can see Jessica saying, hey, I was just trying to protect my father's assets from my brother. I thought my brother was trying to take advantage of him. Yes, I probably shouldn't have moved the money, but however, she had no, you know, illegal intent to do that. So, you know, you have to really, these cases, like I said, they're long, they're complex. We have to make sure we've reviewed all statements, make sure anybody and everybody that's had any involvement, whether it's at the medical, whether it's at the bank, whether it's the notary, or the recorder's office, and then obviously Bill, Jessica, and Terrence. And then look at all the documents and see what was valid and see what was filed to make a real determination of, is this criminal or is this just bad behavior on both Jessica and Bill's part?
And then I think from my perspective, I think it really comes down to how the case would get to legal assistance for seniors. So if this came in somehow directly, let's say from Terrence as an elder abuse case, you know, really what we would be looking at is to start off, can I form an attorney-client relationship? And so, you know, obviously it sounds like there's been at least one, if not two, capacity declarations made. I will say, having viewed a lot of capacity declarations at this point, you know, they kind of wildly vary, even sometimes for the same client. So you always, I think, need to be careful and understand whether the person doing it was trained in doing this type of assessment. You know, I've had clients with 3 or 4 capacity declarations assessments that have the broad spectrum from they're completely fine to, you know, their abilities are completely impacted. So that would be one of the first things I would have to think about. I would speak with Terrence directly and understand, as Krishna was talking about, what relationship Terrence wants to have with Bill and Jessica, if any. What are his wishes? Did he feel pressured to sign those documents? Was he being taken there to, you know, any estate planning folks against his will? And so from the civil side, if it came in as a restraining order case, what I'm doing, if I'm able to form an attorney-client relationship with Terrence, is really intake and understand really what Terrence's wishes are moving forward and see if we can navigate a solution for him. I think more likely this would probably come into our agency, that we would be appointed in a petition for conservatorship for Terrence. And that really has a different kind of flavor in terms of what we're looking at. And so first, you know, I'm still trying to establish a relationship with Terrence and trying to understand what his wishes are. But I'm also at this point probably taking a real close look at whether there was an estate planning attorney involved and trying to dig through who executed the will or in the deed, how was it done. I also, I think like Krishna mentioned, really want to understand Jessica's thought process and why the $50,000 was removed. Is there an accounting? Has it been spent? Is it still just sitting there in the account? Can it be returned? You know, I think if this was to come to our agency and I was representing Terrence as a proposed conservatee, I would have immediately some real hesitation in Bill and Jessica having any sort of official conservator role for Terrence. I think, you know, not that it's impossible, but I think I would need to be convinced that either of them truly has his best interests in mind. And not that, to be clear, not that that would mean that we're trying to take away any sort of relationship that Bill and Jessica have with Terrence. You know, it's just, the question is really, do they have any sort of official capacity in taking care of Terrence and his finances and his person? And that, I think, is a more, you know, has to be a harder kind of analysis, because they've both displayed, at minimum, they've both displayed, I would say, inappropriate behavior, if not criminal, if not really bad judgment. That would suggest that maybe they both have some issues in their ability to take care of Terrence. And, you know, if I'm looking at it at a 30,000 foot level, I mean, this is another example where, like Jill and Krishna said, it is just very complicated. You know, my guess is that a case like this would take probably over a year for the dust to settle, if not longer, in terms of getting the appropriate measures. And not that there are emergency orders and emergency actions that could be taken, but to truly have Terrence safe, stable, getting the support that he needs, just to, I wouldn't be surprised, I should say, that if a case like this were to take over a year to fully stabilize the situation.
Thank you to all of you. I felt like it was exactly what we experience when working cases, and each of you really like demonstrating what the challenges are. I want to encourage our audience to start dropping their questions in the Q&A area, and we will begin that process. But I'm going to start with one, and it's actually to Krishna. Krishna, you said something so important, which is that, police departments and other jurisdictions are really under-resourced, and it's a challenging process. And I sometimes feel as social service providers, we're not always saying the right things. We're often coming to them looking for heroes and saying, oh my gosh, there's elder abuse, and kind of coming undone. And maybe what we need to be using different language with law enforcement to help sort of explain the situation in a different way. And so I always like to say, you speak cop, you work with law enforcement officers every day. So what could you tell us is a way that we should be presenting cases to law enforcement that would make more sense to them, or really just to kind of ping their bells that, oh yes, this is something that needs to come to the top of the pile?
Well, I think what's really important is the nature of the crime. So I think, like, when we talk about elder abuse, because we see it all, it's the wide spectrum, right, of endangerment, financial abuse, physical abuse, sexual abuse, emotional abuse. But really, so then it kind of gets all lumped into one category. But say something's really serious, like we've seen some very serious cases where, say, a mother or grandmother is severely injured by one of their children or grandchildren. And again, like we've talked about, the challenges is it's a loved one. They don't necessarily want to prosecute, but they are severely injured. And so it should come in under, it should be voiced to the police department, in my opinion, of like, this person had broken ribs, or, so-and-so was assaulted and severely injured, so that it captures the, the importance of why it needs to be rushed to the front. Because I will just say, we have all these different jurisdictions, right? From Dixon to Benicia to Vallejo to Fairfield to Rio Vista, the sheriff, unincorporated area. And we have all different types of concerns and crimes in different parts of the area of our county. And I know that, a lot of the police departments are really strapped, for instance, shootings have been up in Fairfield, Vallejo. So that's been kind of at the forefront. But these cases are extremely important to us as well, right? And so we want to make sure that these victims in elder abuse cases get justice. It's just the same as a shooting victim, a sexual assault victim. And so that's why we do dedicate an investigator to only handle cases involving elder abuse victims, because she's become so familiar with the challenges and the issues involved in these kind of cases, and she can devote her time and energy and resources to it. But I do think that when it just comes in as, oh, it's just another 368, unfortunately, they may see, 368, that's the wide gamut, right? So when you kind of talk at the, at the front page of it, of this is what it entails, I think it may move it to the front.
That is really helpful. And I think sometimes we forget that when we're working with different constituencies, we need to sort of voice our concerns differently. So being specific in the kind of abuse and who we believe is causing it, and sort of the pattern. So
right.
Being really clear and transparent, that is definitely helpful. Thank you. So Jill, I want to go to you, and I want to remind everyone to drop their questions in the Q&A. So Jill, we've got a couple great questions here, which is there sort of a guide to capacity declarations that Adult Protective Services and others could be sharing with medical professionals and aid them in completing this document correctly?
I am not aware of a guide, but I'd be happy to look into resources, and we could provide those resources after the webinar. I think it's important to remember that MDs as well as neuropsychologists can complete the capacity declaration. We hear often that from MDs that they are not trained on how to complete the capacity declaration, but all they have to do is have been a practicing physician with the ability to diagnose dementia for a couple of years. And so there are, sometimes you'll find MDs that push back on doing it. and they may prefer to have a neuropsychologist who's well-trained in completing the capacity declaration to take that on.
Mhm. That's great. And we have a question here just right in line with that from Randy. And he's sort of asking, how extensive is the capacity test? And do you know what are sort of the elements of that?
So we have in San Francisco an elder abuse forensic center. Our forensic center is essentially a multidisciplinary team. We have law enforcement, adult protective services, the public guardian present. We also have the district attorney's office, victim services, as well as a geriatrician and a neuropsychologist. And the goal of the forensic center is to bring all of the key stakeholders together to dissect complex cases and to identify the most appropriate solution. We rely on our neuropsychologists to do those capacity declarations. And the neuropsychologists that we work with would prefer for that they have the opportunity to do a very extensive and exhaustive assessment that will likely last a couple of hours. They're going to be testing for executive functioning skills. They're going to be testing for short-term memory, for logic, and also for social and emotional intelligence. And so they prefer to have someone sit down with them and really participate. But I will tell you, in many of the instances that we see in adult protective services, we have clients that are not willing to participate in a capacity evaluation. And so we do find that our neuropsychologists have to get creative. They have to be able to sometimes do half of their questions while standing at the door or standing in an environment that, that may not feel as comfortable as your typical office setting. And so, you know, we work with them to try to make that happen. We also will work with them on the adult protective services side to obtain the medical records if they are available, because most neuropsychologists are going to want to see those as part of their comprehensive assessment.
Oh, that's interesting. Thank you. Jim, we have a sort of a systems question for you. And it's really, I know you've done some great work on this in Alameda County, which is, what is sort of the role of MOUs and grant funding as it relates to partnerships with legal service agencies and other partnerships? And I think that this is such a great question because you and I as partner agencies have an MOU with each other that outlines how we work together, that's constantly, you know, being reviewed. So how have you used MOUs to create that collaborative relationship, especially when you enjoy an attorney-client relationship with the folks you work with?
Yeah, oh, that's a really good question. So, I mean, first off, I would say the MOUs has really been something that I've really pushed in my time as executive director. I mean, I think in this space of elder justice, having those collaborative relationships and having those strong bonds and trust between agencies is absolutely critical. So to me, the MOUs are really just kind of memorializing for a lot of the agencies. It's really just putting in writing what we're striving towards. And I think we're really lucky in Alameda County that the elder justice space is really collaborative. I think we all really understand the importance of having each other at the table and how much that improves outcomes. So that's been a really positive experience, I think, both for the agency and for clients. I think in terms of grant funding, I mean, as a nonprofit, I would say 90 to 95% of my applications require, and I think rightfully so, for us to demonstrate how we're collaborating formally and informally with other agencies and making sure that we're providing those holistic services and we're thinking well beyond just our four walls. In terms of how that interplays with attorney-client privilege, that's a really good question. And really, with all of our partners, what we're doing is leading, it's client first. And so, you know, we have a menu of services and MOUs and partnerships that we have with other folks that really will be at the client direction. So we can offer up a menu of services and say, you know, hey, we have a relationship with adult protective services, with food service providers, with, you know, in-home care. And do any, you know, would you like us to connect you with any of these things? And so where we really have to differ, but that does point out a big differentiation of where legal services has to be a little bit different from social workers, because we're not social workers. It really is at the client's direction. And so if a client, you know, we can see that a client is hungry, that there's no food in the fridge, and we can offer up that connection. But even if I have an MOU, even if I have a really great relationship with my local food bank, and my client says no, that just means that I can't be the one to make that referral, unfortunately. And I think for a lot of family and a lot of folks who see what we see, don't understand that as lawyers with attorney-client privilege, like I really am at the direction of my client. And so I think that leads to a lot of community frustration, which I completely understand, but is kind of one of the big differences, between legal services and social services.
Yeah, I think that highlights something really important, which is in the same way that we have long-term care ombudsman, we are only allowed to address issues that our clients allow us to. So we're not mandated reporters, and we work for them. It's really having, we get our marching orders from them. And I think that sometimes that's confusing when we're dealing with elder abuse. We also, as providers, are uniquely positioned to hopefully get that client to accept those services because we're able to destigmatize it, that no, this is a normal thing and we work for you, and you get to tell us how you want to be treated. So to Jill, I have an interesting question here, which is, how has the pandemic complicated things or made things a little more challenging for the process of reporting and investigating and pursuing solutions? Do you have any guidance for how providers can navigate this new normal?
Well, I feel more comfortable in San Francisco that we are receiving reports because our APS reports have basically gone back up to pre-pandemic levels. Mm-hmm. The agency that I work for, the Human Services Agency in San Francisco, since March has seen a massive dip in reports to the child abuse hotline, but not the same with elder abuse. We saw a slight dip happen in March and a little bit into April, and now we're back up to pre-pandemic levels. Most APS programs in California are operating also in pre-pandemic protocols. We've outfitted our social workers with appropriate PPE, and they are going out and investigating. There's a few counties that have asked the state for waivers, and they are responding on an in-person basis in a slightly reduced way. I will say that we have seen with the pandemic tremendous difficulties finding long-term care placements for clients that are needing higher levels of care. And for individuals who are referred for conservatorship, it may be more difficult than ever, and it's always been difficult, to find an appropriate licensed care facility that will take them on right now because they do have COVID-related restrictions.
Thank you. And I also want to remind everyone that while ombudsmen do not do placement, if you are needing guidance around the long-term care system, feel free to call your local ombudsman and see if you can get guidance about what may be a good fit or ideas about where a client may be happy. So remember too that the elder abuse spectrum is broad. It includes adult protective services and ombudsman and others. So I'm going to close out with our last question, and anyone can feel free to pick this up. And this is related to that issue of sometimes we're speaking different languages than different social service providers, and we're not quite communicating clearly. And sometimes we end up in the space of a client appears very clear at one moment, and then maybe later in the day or a few days later, they are not. And so it depends on when different service providers interact with them, or even police, if they feel like it is elder abuse. And so I want to ask, and whoever would like to pick it up, which is when we are in an issue where it feels like it's sort of in, it's sort of out, and we fear that as this progresses, the abuse will get worse. Do you have any tips that we can use to get the person to the right parties at the appropriate time when it is sort of back and forth, and how to handle those situations that are a little bit gray?
I can start with a quick tip. I think from my perspective, I think this seems really shows sticking with clients. I mean, so many of our clients, it takes a while before they're ready to take action, before those steps. And so I think having some patience with the client, I can think of several cases where I spent 6, 7, 9 months speaking with a client before they were ready to move forward and take action. And I know that's a little different from capacity. And so, but I still think, patterns emerge after some time. And so I think in cases that are gray in terms of anything, capacity, wishes of the client, any of that, adding time to that, as uncomfortable as it may be, and it obviously depends on the severity of the situation, but if you have the luxury of time, I think sticking with someone and settling in, I think for me, I feel like the more time I give it, the more patterns evolve, the more patterns emerge, and I can see the situation more clearly, where at the start, with one or even two visits, it might be really murky and tough to make the appropriate call. So giving it the time, if it's available, would be my kind of advice.
Mm-hmm. Jill or Krishna, would you like to chime in on that?
Sure. I'd just like to say, again, I know I keep talking about Elaine Perry, but I feel like she's so instrumental in these cases. And she does a lot of the hand holding. I can't tell you how many times she goes out to the scene or to the house of the elderly victim and meets with them on a regular basis. And I do think that's so important for the familiarity, and also that they gain her trust and in their working relationship. And so she always is pointing them in the right direction in terms of if something that we can't assist or do. And I know we have resources at the Family Justice Center. I know ombudsmen's at the Family Justice Center, but there's also a lot of resources that show, whether it's Solano County Mental Health, community care licensing, the Department of Social Services, the investigator's office at the Solano County Courthouse in terms of for the conservatorship, health insurance counseling advocacy program, North Bay Regional. There's a number of resources that if they need, she puts them in contact with. But it's really, I feel like that relationship that she develops with them, and there's this trust build, and then so that she can do what she believes is the most important thing for his case or her case, right? Which is number one, their safety. Number two, we want to make them whole, and we want them to make sure that they're heard, and we want to get them and connect them to the right resources and services.
Excellent. Jill, did you have any thoughts on that?
So just really quickly, APS from that perspective, it often will engage in what's called watchful waiting. And what that might mean is that a case needs to be closed when the abuse has not actually been resolved. But if you are going to build a case, whether it's a criminal case or whether you're building a case for conservatorship, allowing that individual to fail and then intervening at the right moment can really help you to build that case and then to finally reach a successful intervention.
Mm-hmm. Absolutely. And I think partly what you're all hitting on is like it's possible there may be what's considered a failure or a real hard spot before resolution is made. And I think that's just kind of the hard part of working with adults, that adults get to make bad decisions. And so that you have to be willing to stick with it and acknowledge that may be hard for you, and that's require a lot of self-management and a willingness to just stick with something or come back to it when it's the right time. And that there are no black and white answers. To those of you who had put questions in the chat that we didn't get to, we will be hopefully getting our presenters to answer that at a later time. We'll include in the recording. I want to remind everyone that the link has just been added to the chat, and you can register for next month, which will focus on abuse in long-term care settings. So you'll be coming to the Ombudsman House, and we will be talking about some national and statewide issues. I want to thank all of you for joining us today. I want to pay a special thanks to our speakers, Jim, Krishna, and Jill, who were leaders in this area and who have been very generous with their time. I appreciate them being part of it. Also, thanks to our planning partners and sponsors, Kaiser Permanente and others. And again, thank you to all of you for all of the work that you do and your commitment to continue learning. Look forward to seeing you next month. Again, we'll have Lori Smetanka from Consumer Voice and Joe Rodriguez from the California Department of Aging, the Office of the State Long-Term Care Ombudsman. I hope you all are doing safe and staying safe and well, and we'll see you next month.